Good evening, everyone. My name is Krishnendu Mukherjee. I'm a barrister and Indian advocate at Doughty Street Chambers. And I'd like to welcome you all to this, both in the room and online, to this joint event with Doughty Street Chambers and Unison, Business and Human Rights Roundtable on Public Procurement Due Diligence. I recall that in the joint statement done by the governments of Australia, New Zealand, Canada, United Kingdom in 2018 on principles to guide government action to combat human trafficking in global supply chains. Principle 1 of that joint statement was that governments should take steps to prevent and address human trafficking in government procurement policies. This would include adopting appropriate due diligence processes to identify, prevent, mitigate, remedy, and account for how they address human trafficking. Obviously, those processes will also look at human rights and environmental violations as well. However, in Section 47, the newly enacted Section 47 of the Health and Care Act 2022, which came into force because of the high-profile forced labor in the Uyghurs, forced labor in the supply chain. What it mandates is a review into NHS supply chains, including those which are cotton-based, but certainly don't provide any mechanism for due diligence or indeed remedy. And so there's a gap, I think, in reality between UK's rhetoric on public procurement due diligence and its action. And we also note that the amendment to the Modern Slavery Act 2015, which would bring public bodies into the purvey of the Section 54 of the Modern Slavery Act, hasn't been tabled yet. So to look at this gap, we have three eminent speakers. We have Gemma Friedman from Unison, International Officer at Unison, who will begin. Then we have Neil McInnes, who's a partner at Pinsent Masons in white collar crime and regulation. And then we have Claire O'Brien, who's a reader in law at the University of Dundee. For those, and we're very pleased to have an face-to-face, the first since the pandemic, Business and Human Rights Table. So those who aren't familiar with the Business and Human Rights Tables, the speakers will speak for approximately 10 to 15 minutes, after which we'll have time for a Q&A, which you can indicate by putting your hand up, or if you're online, by also putting your hand up as well. We don't want to exclude you. And then at around 8 o'clock, we'll adjourn for refreshments. So again, thank you very much for coming, and we'll start with Gemma. Thank you.
Then I can turn and look at my slides a little bit as well. Oh well, I'll stay here. Thanks very, very much, Krishnendu. I'm really, really pleased to be here tonight, and hello to everyone in the room and everybody online. Thank you to Krishnendu, and also to Martin Westgate QC, who at Doughty Street Chambers, who are working with us at Unison to try to break new ground and work out how a UK mandatory human rights and environment due diligence law can be applied within a UK public sector framework. For time's sake, I'll have to make some assumptions that there's a decent amount of knowledge that the audience has around mandatory human rights and environmental due diligence in general. But I'm just first of all going to take a moment to set the scene. So at Unison, we believe that the UK urgently needs a new law to hold companies and the private and the public sector to account when they fail to prevent human rights abuses and environmental harms in their global supply chains. And if our vision comes to pass, It will be a world first because the public sector is not included in such a law yet. So we really are hoping to spark some new ideas and thoughts this evening with you. We're calling it, as a coalition, a UK Business, Human Rights and Environment Act, and it's modelled on the failure to prevent provisions of the existing UK Bribery Act Section 7, which has already been recommended by Parliament's Joint Committee on Human Rights. Coordinated by Corporate Justice Coalition, we are 37 organisations united in supporting a set of key principles for what such a law should include. It would greatly enhance the protection and realisation of human and labour rights around the world, including in the UK, and contribute to meeting critical global climate and biodiversity targets, as well as defending people and the planet against the impacts of catastrophic climate breakdown. And it would ensure that Britain is at the forefront of setting standards for renewed prosperity and sustainable trade worldwide, and would level the playing field for British business. It would provide a really overarching framework for tackling irresponsible business conduct, including those tied to public procurement. And it would complement and go beyond existing sectoral or issue-specific legislation approaches while reducing overall compliance burden for business. Are we on my slide? Oh, it's my fault, in fact. Teething problems. Let me go to it. Thanks. Much of the detail is already agreed amongst us, but coalition working always takes some time. And so some important parts are being decided upon right now, including how the law should apply to the public sector similarly and differently than the private sector. Companies surveyed by the British Institute for International Comparative Law a few years ago found overwhelmingly that they do not have certainty, and that they believe a new law may provide clarity and certainty that they need. And so, unsurprisingly, so far, we already have 47 businesses and 39 investors representing 4.5 trillion in assets who have already joined us in our call for human rights and environmental due diligence legislation. And it should be no surprise, given the state of our of inequality in the UK, that a YouGov poll showed that 4 in 5 people in Britain across all segments want new laws to make sure that business stamps out environmental damage and exploitative practices in their supply chains. So within our short set of principles, the elements, we have this clause here, which is the clause which you can all read. I won't dwell on it, but that's the clause that we have, which includes the public bodies, but also export credit agencies, development agencies, and development finance institutions. So what's our motivation at Unison? We have a lot of motivation in this. You know, we are the UK's largest public sector union. We represent 1.3 million workers, members in the UK in the public service, mostly in the public sector, but a decent number who are also in privatized public services. And we've got a really strong history of internationalism. Many people often don't really get to hear about what we do within the trade union movement globally, but have a look into it. It's actually really exciting, and really proud to be in it. And so we offer solidarity to public sector workers all around the world. And we at Unison are extending our solidarity to workers everywhere. We shouldn't always have borders of public sector workers just supporting public sector workers, for example. But we've also got, of course, a vested interest. The public sector could not function without our members, including thousands who work with or who work as public procurers. And it's our members, particularly those in outsourced sectors, such as social care, which I think could also benefit from our proposal, and I'll explain why later. So we also believe in, of course, quality, strong quality, well-resourced public services. We know that when it's done right, the public sector has so many positive multiplier effects. Poverty and inequality reduces, our environment improves, social capital, unity is built socially, and the institutions of democracy, as well as democracy itself, become strengthened. And with a nearly 300 billion public procurement spend, you know, surely it should be at the centre of playing a key role in delivering that in not just the UK, primarily the UK, yes, but around the world too, because we're so interconnected and interdependent. We also have, you know, let me go back, I've moved on too soon. There's also, under the United Nations Guiding Principles on Business and Human Rights, the state has a duty to protect, and corporations have a duty to respect, and they all have a duty to provide remedy. Public procurement sits between those, but our procurement laws and systems are absolutely not fit for purpose. And I don't have any faith that the government's new procurement bill is going to necessarily make that any better post-Brexit. Unsurprisingly, the public procurement profession has fallen far behind the private sector. Power. I'm going to take this from a situation around modern slavery as an exemplar. In my opinion, in our opinion as trade unionists, there's been too much focus on it. It doesn't get to the root cause of the problem, and that is that there's structural power imbalances between workers and employers. And union busting, which is a system where corporations deliberately spend a huge amount of money stopping unions from getting a foothold in workplaces and getting collective bargaining agreements, is rife throughout global supply chains. And it's enabled increasingly by authoritarian governments. But yet, where's the conversation about that? It's a conversation that focuses on cherry picking sexy topics. And then debate. So we want to be influencers in the debate. We want to be ambitious because people and the planet deserve us to be ambitious. So we want to start to set the terms of the debate in the UK, and of course, with the Labour Party, who we are affiliated to, it's the natural target for us. And let's hope in a certain number of months, we actually get a change of government and that it is the Labour Party. And given the fact, when we talk about a debate, that there's a copycat nature of laws in the, you know, around the world, we want to have multiplier effects, and we hope that we will by sparking this debate. So where are we at right now with the legislation? Well, France was the first in 2017 to enact their duty of vigilance law on parent and outsourced companies. And they were the first to show that respect for human rights and the environment can be legally mandated into business activities. It has a high coverage. There's lots of problems with it, although, you know, well done to France for putting it out there. And it does not apply to the public sector. But since 2017, 7 lawsuits have been filed, and all cases are ongoing. Then we have Norway. Their business transparency, human rights and decent working conditions law came into force in July 2023, and it includes some state-run public sector entities which operate as enterprises, such as the railway system. In Germany, their law on supply chains came into force just a few months ago. In the Netherlands, they've already had a relevant child labour law, but a group of political parties have now proposed a business transparency, human rights and decent working conditions law. And a year ago, the EU published its proposal, which Claire will, I'm sure, touch quite a bit on, for a directive on corporate sustainability due diligence. Further, there's some form of political process which exists in 6 other EU countries and campaigns in 8 other countries, including the UK. Canada also has a campaign to provide for liability and remedy. And also, interestingly for us, in Australia, they have a Modern Slavery Act, which does require large entities based or otherwise operating in Australia to report annually on how they are addressing modern slavery. Thank you. So I will move on. So law, a little bit around the law that just shows here that it's not fit for purpose. So there's a new a limited due diligence provision in the Environment Act from 2021, but there is no mandatory human rights due diligence. In BEIS, the Business Enterprise Industrial Strategy Committee in March talked about it not being fit for purpose, although there is some progress that's being made in the courts right now in terms of the ability for UK courts to have jurisdiction to hear cases where violations have happened abroad. There has been a legal opinion about how the law would act on the private sector, which was on Boohoo. You can get that online, and that it would have been held accountable under the legal principles that we are suggesting at this moment. And so back to the public sector. Modern slavery exists not just in the UK, abroad, but also in the UK. And there's three case studies here, two of which are about modern slavery and social care that's happening right now. But it's not just the two that I've put up here, and thanks to the Guardian and Observer for those. But also there's other cases. There's a case right now that we're working on at Unison in Scotland. There's another that got brought to me around a Nepali case. It's happening. It's rife. These are supply chains. They might be short supply chains, but they are supply chains. There is subcontracting. There are recruitment agencies. There is illegal recruitment fees which are being charged. And so the question has to be, why would we not apply this to public services as well as public sector products, such as rubber gloves, of which there's been some really interesting developments recently, where the UK Department of Health was forced to scrap how it sources medical gloves for the NHS after the supplier was accused of modern slavery by some claimants who were represented by Wilson's solicitors. And indeed, there are other issues, union busting. I work with a Sri Lankan trade union where Ansell, who call themselves Ansell Protects, has continually busted the trade union in their Ansell Lanka factory. And the list just goes on and on and on, and the links back to the public sector, including in electronics industry, where I am on the board of Electronics Watch, a brilliant organisation I would suggest you look up, are happening. So even when we get settlements out of court after judicial reviews, how do we stop this from happening again and again and again? Where are the sanctions? Like I'm saying, it's not fit for purpose. So finally, from vision to position, and this is what we're trying to look at tonight. We want to have a joined up government. We want to have a strategic approach that makes the best use of spending power for the good of people and the planet in the UK and everywhere else. And we want to disrupt that terrible race to the bottom in terms of standards that has been going on for far too long. And we're not naive. We know that this is the long haul. We know that but everything takes the first step. So in no particular order, we know this will also take a lot of resources. There needs to be, but it's justified, and we think that it will pay for itself in lots of different ways. And there'll be some amazing research that could be done, if it hasn't already been done, about how it would pay for itself. I'm sure it must be out there already. And we believe in it. There needs to be a shared framework. In some countries around the world, this is starting to happen. For example, in Sweden, the 21 regions are already decided to work together and have been doing so to fulfill a politically driven code of conduct. They charge 1 krona per person, and it's to co-finance the Swedish county councils. They have requirements directed at the suppliers, but internally they also have a process to own due diligence risk processes, identifying, prioritizing risks, planning, sharing audits, follow-up, reporting, etc. And they're currently revising their policies and contracts to include remedy, vulnerable groups, and human rights defenders. And we've also had myself, Krishnendu, and Martin Westgate, a great chat with James Cochrane, who's the New South Wales Anti-Slavery Commissioner, where they're also setting up a shared framework there, where there's 128 local councils, health bodies, and they all have to report on their spend across all categories. And they have an anti-slavery commissioner function, which is they're building from scratch, when they're taking a systems approach to be proactive all the way. So they want to be proactive, and that's what we want too. We, you know, these are our members who are procurers. We want to be first and foremost, we want them to have the resources, the training and the tools to be able to take action. But in order to do that, we probably need a regulator. In fact, already looking into the private sector, Kingsley Napley concluded that a private regulator, that a regulator, a dedicated regulatory body, could add significant value. So we would want a regulator to undertake complaints and investigations. We would want to be at the centre as trade unions of stakeholder engagement, and we'd need resources to help us to do the best job too, which is why we also need it to be cross-government. And really importantly, there needs to be judgment. There needs to be some form of sanctions, but we wouldn't necessarily want to see the public sector being taken to court for huge, libel cases. We want this to be a positive incentive for the public sector. And finally, and really not least, there has to be a role in which the public sector provides genuine remedy, not from a top-down approach, but from a bottom-up approach. And at Unison, we're engaged, as well as with the University of Greenwich and Dr. Olga Martin-Ortega, who's here, we're developing some joint principles for a worker-driven remedy process, which we will also be trialling and testing together. So I've probably way overrun my time, but I hope that it's all made sense and that we've sparked a debate here this evening. Thank you.
Thanks so much, Gemma, and it's really inspiring to see the lead that Unison has taken in relation to what we know to be a very underutilized initiative in terms of public procurement due diligence. But what we do have is some experience in relation to the Bribery Act 2010, and Neil is here to talk about perhaps some of the parallels that we can draw between the Bribery Act and what we're discussing here today. So over to Neil. Thank you.
Well, thank you, Krishnendu. Thank you also to Gemma just now and Unison for helping Doughty Street host this event. I should say a few words to begin with what I can't cover, what I won't cover, just to get my excuses in early. I'm a corporate crime investigations lawyer. I'm a white-collar crime lawyer, so I'm not going to talk about procurement law. Maybe some of you would be pleased to know that. I'm also defer to some of our experts on other areas of subject matter interest tonight. What I hope to do is, through a look at the UK Bribery Act, a model that Gemma's mentioned, Section 7, to look at some of the challenges about the expansion of corporate criminal liability that uses that failure to prevent model. There are opportunities, but there are challenges. And I'm not here to advocate a policy position either. I just want to share my experience through the last decade or more acting for companies developing their compliance programs. And I've worked across the world doing that. I've spent nearly 5 years living in Asia, doing investigations in sort of pretty challenging markets in Southeast Asia, North Asia, and elsewhere. And I've probably got a perspective that has seen the journey of the corporate compliance program over the last 12 years since the UK Bribery Act, which I hope will be useful. But please challenge me. I'm keen to have a debate about it. But I hope it's useful just to see what can and cannot be achieved, and what maybe some of the critical challenges or tests might be if you're going to expand. Anyone is going to expand the failure to prevent position. So I'm not going to advocate a policy position on this. I just want to share with you some themes, which I hope is useful. And I've got to work out how to turn the slides now, which is always the first challenge with these things, but let's see if that works. It does, great. So let's take, forgive me if I spend a minute on the history. The Bribery Act came about in 2010 in pretty peculiar circumstances. The laws of bribery, if it's of interest to anyone, before the Bribery Act were a series of anachronistic, very, very difficult statute, common law, that used concepts which were totally unfamiliar to all of us in 2010. It was a sort of Victorian era series of concepts, very hard to prosecute. That's the first thing. So there was definitely a need for a refresh of the bribery law at that time. There was also stinging international criticism of the UK, criticism of the failure to enforce effectively, to uphold its obligations under international instruments for anti-corruption. And there are other localized difficulties with corporate criminal legal tests in the UK, which still exist. So I'm sure everyone's aware that for a corporate to be substantively liable for a substantive criminal offence, the traditional test in criminal law is that you have to show that the directing mind and will of that company was involved in the offending, essentially, and then it's imputed to the company. Now, to show that the directing mind and will of a company was liable for an offence, you have to show normally that the board of directors was involved. And in large multinational corporations, that can be challenging. And in fact, the board may not know about some very, very serious offending. So lots of criticisms there that need to be met by a refresh on bribery laws. But one of the things which I think is really important to understand around the growth of failure to prevent offence debates is bribery was seen as one of a limited category of offences where English criminal law had a scope to be extraterritorial, to look at offending outside of the UK and criminalise it in UK English courts. And that had been enshrined before the Bribery Act, and it was also critically enshrined in international instruments which we'd signed up to. That criminal law, not some other form of liability, but criminal law in the UK should have extraterritorial effect for bribery. And that has been a way that the Bribery Act could unleash itself, essentially. So when we're reflecting about the growth of failure to prevent offences, that is quite an important marking point. And it's one that the Law Commission developed last year when it looked at corporate criminal liability in its June 2022 report. And it does talk about, has a case been made for extraterritoriality, which means has a case been made for the criminal law, not some other form of liability in the UK courts, but criminal law to extend extraterritorially. I think that's something we've all got to have in mind. Now, bringing in a failure to prevent offence creates lots of debate. And I think the other thing to share about the history of the Bribery Act is that there was a huge amount of press interest. You might remember, some of you, that people were saying that, oh, the Bribery Act's going to make business uncompetitive. We won't be able to take our clients to the Formula One. You know, these sort of really big challenges of the day. And some of that was just a sidebar kind of debate. Okay, so we can probably ignore that if you're thinking about a new failure to prevent offence, but some of it is quite critical to understand that there's still challenges around. The Bribery Act, and you might say rightly, doesn't distinguish between the size of an enterprise. The offence of failure to prevent bribery applies to all manner of commercial organisations caught in the Act. And there might be particular challenges, particularly if we're looking at due diligence commitments for small and medium-sized enterprises, SMEs. And so any kind of law change in this area really needs to maybe reflect that criticism that was there at the time of the Bribery Act, and probably the Bribery Act hasn't adequately resolved. And in fact, if you look at the case law, one of the only cases that has made it all the way through to trial has been a small and medium-sized enterprise. Okay, and so has there been an imbalance there inadvertently? So let's just have a look at what I'm talking about the failure to prevent Section 7 offence. And apologies if you're familiar with this, and you will see it. I've chosen the smallest font possible, it seems, for this room, so apologies. But another feature of failure to prevent offences is how they've been structured. In the Bribery Act, as an example, others have taken it. So let's just have a look at it. A relevant commercial organisation is guilty of an offence under Section 7 if a person associated with it bribes someone intending to obtain business or retain business for that commercial organisation. Disentangling that's a sort of strict liability. Okay, we all agree with that. You're strictly liable if you're at a company. If someone on your behalf, that's an associated person, someone who's performing services for you, pays a bribe, commits the substantive criminal offence, and then they have an intention to obtain business or some advantage for you. And one of the debates around failure to prevent offences that apply to corporates is there some connection between the corporate and the harm? the corporate here benefits, and so that justifies in the view of some the strict liability. But as a additional point, there's a defence for a corporate to demonstrate in the Bribery Act its adequate procedures. So that's a compliance programme. But I think we need to think about, when you're expanding failure to prevent offences, how would you connect it to the corporate in terms of benefit or culpability? That's not always obvious in all the debates I've seen. It may be in others, but it's a test that will be important for any debate in Parliament on this, I suspect. So that's a little bit about the mechanics, which I think is important to reflect on. And then even a smaller font now for you all, sorry, is some practical impacts. So there's no doubt that the Bribery Act has had a colossal impact globally in terms of imitation, I suppose. Imitation is a form of flattery. You have laws that have developed elsewhere that have this affirmative compliance defence, not necessarily calling it adequate procedures, but corporates are liable if they fail to prevent something, but they can raise the fact that their compliance programs were intended to prevent this, and they may fail, but they use their reasonable endeavours to have compliance programs. So you've had that as a trend. You've had other laws already in the UK. I'm sure you're aware of the Criminal Finances Act. That's to do with the facilitation of tax evasion. And going back to that Law Commission report, we've seen since the Law Commission report a debate around the amendment to the Economic Crime and Corporate Transparency Bill, which it's worth having a look at the amendments proposed by Buckland and others, which have led to the bill, that aspect of it being withdrawn, but there's a likelihood that there will be legislation on failure to prevent fraud, failure to prevent false accounting, and failure to prevent money laundering. So there's definitely an appetite for looking at the failure to prevent model further in the UK. But the other aspects of what we've seen over the last 10, 12 years is the Bribery Act in practice has led to a real expansion in corporate compliance programs. Obviously a hugely positive thing, and corporates have embraced it in so many different ways. And my clients are regularly instructing us to look at their programs and come up with enhancements. And that's the experience of practitioners across my area of work. That involves risk assessment exercises, training programs, resourcing whistleblower, speak up hotlines, policies, procedures, as well as due diligence. And all of that has led to a growth of internal investigations, a sort of privatisation of the policing of compliance. You've got to be bear in mind that a lot of compliance programs will lead to an awful lot of private, in the sense of internal corporate investigations. And alongside that has been a real debate within corporates about business ethics more widely. You can't just look at anti-corruption and say, okay, I'm going to do due diligence on anti-corruption, vet all my supply chain for that, and just ignore everything else. That's not happening. There's a great deal of distance that's already been travelled on that due diligence, which you might argue, if you're wanting a law on another area of compliance, that could be bolted on. But whereas the Bribery Act has been a step change, a quantum leap in compliance programs, in my experience, you might only see incremental change if you're adding in other subject matter areas. But it's important that that framework is already there. And commitment, I think, you'll find from most leading companies and their boards around the importance of these issues. That's happened, remarkably, you might say, with a very limited enforcement environment. That's my final point on this slide. We've had only a handful of cases that have been brought for corporate corruption. I say a handful, there's more than a handful, but you're not looking at stacks and stacks a year. Now that's because they're complicated still. It's also the resourcing of law enforcement. And that's just going back to perhaps the point Gemma made about, well, who's going to regulate this, or who's going to be, we do all at the moment have a law enforcement community that is extremely under-resourced in the UK. And to add in another suite of failure to prevent offences, there has to be an impetus to resource that properly. And I suppose going to resourcing and looking at the public sector, I'm not working in the public sector, but I know how much time, effort, resource a corporate compliance programme takes to build and run effectively to make it work. For any kind of failure to prevent offence, which involves the public sector, it has to be that there will be a resource requirement on the public sector, because it only works if everyone in the chain is involved and engaged in the compliance efforts. It only works if people are asking the right questions at contracting. It only works if people, when they get the responses, know what it means. You need to train up, you need to have specialists, and that's a big resource commitment. And certainly that's, there weren't compliance departments in some companies 15 years ago. Now they're enormous in many cases. And they're trained professionals. And if you look at what the regulators are saying globally, they're not expecting someone to be double hatting this. You have to be specialist. You have to really know your onions. So there is something to be said for looking at these considerations very carefully when you're growing failure to prevent offences, or if you're thinking about doing so. Now, I'm going to be controversial now. I'm going to throw up another model, which is another part of my practice. I work a lot on development bank investigations, which, for those of you who don't know, multilateral development banks, I'm sure you'll do, fund a range of different projects globally, often in emerging or developing markets. And if they're financing a development or project, they have strings attached, understandably. Some of those are compliance related. They're called prohibition of sanctionable practices, non-collusive behaviour, non-fraudulent, prohibitions on fraud, corruption, obstructive practices. And if anyone involved in a project financed by a bank commits any of those sanctionable practices, they can be debarred. And they can be debarred permanently in some cases. And that means a business is no longer able to tender for any other finance project for the period of their debarment. There are ways off that debarment list, an integrity compliance programme, similar to what I was talking about, adequate procedures, perhaps, you might say, very similar principles. And the impact of this can't be underestimated. We did some research a couple of years ago just to see how many companies around the world, where they were headquartered, who've been sanctioned by the World Bank. There's also the Africa Development Bank, Asia Development Bank. Now, if we're looking at the procurement processes of the public sector and where they're operating, we've got a procurement bill. Hands up, I'm not a procurement lawyer, so I'm not going to comment on the bill. But we have a procurement bill, which I think is going through Parliament at the moment. And that has a debarment concept that's been supercharged a little bit. Don't know where it's going to get to, but there's a talk of a debarment list, just like the banks in these multilateral development bank cases have lists, which name and shame people who've breached the contracting standards. And we'll all be aware that under procurement rules already in the UK, there are various compliance breaches which can lead to either mandatory or discretionary exclusion. So when we're thinking about the difficulties I expressed about the criminal law and the extraterritoriality, let's not forget that there are a range of other ways that corporates are currently complying with other standards contractually, and this is one way. And then the other aspect that I think is really developed, and it's worth thinking about a lens here, and where you put your efforts, is the changes that we've seen, the debates we've seen about business ethics and culture. And you can have, if you remember, there was a slide about that wheel with all the different bits of a compliance program under the Bribery Act. That's all great. But if you don't have the culture and you don't invest in corporate or business or organizational culture, we've seen organizational culture fails in the public sector as well as the private sector. If you don't get those cultural issues right, then the compliance program probably won't work anyway. Now, this is a former prosecutor. He was a prosecutor at the time, Preet Bharara, US celebrated Southern District New York prosecutor. He talks about 3 culture fails, which I think are really significant prisms into this idea of how you change behaviours in complicated compliance issues. Culture of minimalism, which means almost what it says, you only do the bare minimum to comply with the law and nothing more. That's going to be a fail because you'll probably transgress that. The culture of formalism, you tick all the boxes. Yeah, we've done our questionnaire, we've done our due diligence, but we haven't really spotted the elephants in the room. Okay. And the culture of silence, which we see in the public-private sector as a continual issue. Private sector companies I act for have invested thousands and thousands of pounds every year on speak up hotlines, people manning them, staffing them, sorry, people investigating off the back of them. and encouraging people to speak up. You need that to have an effective compliance program. But these are all things which I think are as equally, if not more important for successful compliance as the stick of a failure to prevent offence. So concluding remarks for me would be, don't forget procurement laws and the ways that you could harness issues through them. Don't forget the fact that if it's a public sector due diligence law, that's going to require a huge resource commitment to make those to make any kind of requirements through the contracting really effective, as opposed to the culture of formalism. And then there are technical legal points which I've made around failure to prevent offences, which need to be thought through. The grounds for criminal law being extraterritorial in different areas beyond what we've already established, and which has already been quite hard to establish in bribery and else, in other limited categories of offence which can be prosecuted in the UK, which happen elsewhere. And then a reflection really that probably the law enforcement aspect of all of this is the smallest aspect. We've seen that enforcement of the UK Bribery Act has involved a handful of the most egregious cases. Okay. So if you're wanting adequate remedy and redress, I just throw it open that the criminal law may not be your route. So I don't mean to spoil the party or be too controversial, but I think these are points we all have to work through and discuss. Hope that helps.
Oh, thanks. Thanks very much, Neil, into that insight into an area of law certainly I don't know much about, but it's welcoming to see that the threat of sanction has sort of caused companies to put in due diligence processes where they otherwise wouldn't. And what you talk about, a cultural shift, was actually something that the New South Wales Anti-Slavery Commissioner was talking about a lot. It's not just a question of putting in guidelines or supervision, but actually it is in many cases in the public sector, especially, it's about a change of culture, and that's something that he echoed. And our last speaker, the clicky, yeah, is Claire, a long time expert on business and human rights, who I first met, I think, in one of the UN forums on business and human rights many years ago in Geneva, who has written on public procurement due diligence, and her topic of her talk today will be on the scopes and challenges for remediation. Thank you.
Thanks. Yeah, it's really good and important to talk about anti-corruption, because it is often relied on in advocacy around duty to prevent and the idea of national, due diligence legislation, or indeed business and human rights treaty at the United Nations level, which would require states to enact due diligence laws at the national level for companies, which would also include liability, civil liability for harm to human rights and the environment, potentially climate change as well, that results from due diligence failures. But just to sort of continue in the party pooping vein, I don't think there's any analogy actually between as a regulatory project, between trying to prevent corruption and corrupt acts and bribery, and a broad scope corporate due diligence, which intends to mitigate, prevent, address human rights breaches, defined with reference to all human rights instruments, all internationally enacted human rights instruments. I think these are completely different projects, and there's really no good analogy, and that makes it really so important to understand the UK example, and of course the other, as you say, the other legislation which has emulated it subsequently. So yeah, really good things to talk about. Now I'm going to try, it's going to test my mind-hand coordination because that's too far away for me to see. And I'm going to try to look at my slides here and advance them here. Good. So if we're talking about public procurement, due diligence, those two things in combination, we are, I think, still in the domain of the UN framework on business human rights and UN guiding principles on human rights, devised by John Ruggie there under the leadership and at the request of Kofi Annan. Of course, just for anybody who's not familiar, 2008 UN framework on business and human rights affirmed a three-part framework: the state duty to protect against business-related human rights abuses, the corporate responsibility to respect human rights, and the right of victims to access an effective remedy for business-related human rights violations or abuses. And when we're talking about public procurement, of course, we're sort of spanning all three pillars of the framework. We're in the domain of the state's duties and the state's positive duties to prevent harm to human rights by corporate actors through the enactment of regulation and their enforcement. We're also, of course, indirectly looking at corporate responsibilities to respect human rights and to operationalize those through due diligence as well as remedy. So we're sort of spanning all three pillars rather than just focusing on the central pillar, which we do when we talk just about due diligence legislation, corporate human rights due diligence legislation. In the guiding principles, the responsibility of companies to do due diligence is spelled out in quite clear terms. It extends not just to companies' own impacts they cause through their own activities, but the impacts they may have on human rights through business relationships, including, of course, procurement and contracting. The due diligence responsibility applies to all enterprises, but is a scalable and flexible concept, a scalable process, which is intended to be adapted to all the different characteristics of businesses. But of course, when we get to, and that's the due diligence process envisaged as a sort of iterative, continuous improvement cycle, and one which operationalizes the corporate responsibility to respect. But when we look back to the UN framework and the guiding principles and assess what they say about public procurement, there's not so much, actually. It's more of a promotional treatment that public procurement gets, which is interesting and, you might think somewhat ironic, given that the state is the primary duty bearer under international human rights law, and companies are not directly addressed by human rights obligations. Why then in the UN framework and guiding principles is a much clearer and more articulated responsibility spelled out for due diligence when it comes to companies versus the state. And that sort of more exhortatory, permissive sort of approach in the UN guiding principles, guiding principle number 6 there, is carried forward in other materials of the guiding principles era. The 2011 white paper on CSR of the European Commission, for example, simply invites member states to make full use of all the possibilities offered by the current legal framework for public procurement. And in terms of commitments made in that otherwise important policy document in terms of defining the EU vision for the decade that was to come on business human rights. All really that member states Commission and member states have been prepared to do was to sort of, again, encourage the integration of social environmental considerations in the procurement context, and carefully making reference to the limits of what's permitted by EU procurement law in that context. And what we see in the buying social guidance of 2011, which was sort of updated to reflect EU commitments on responsible business at that time, again, very sort of open-ended and soft references to human rights, which, as we'll see, contrast to what's now envisaged for companies. And so you begin to wonder already when you look at all this, what's really going on here? Why is the state, why are they soft pedaling on the state when companies are, increasingly getting it in terms of their human rights responsibilities? And if you look actually at the 2014 procurement directive, which was at the time sort of much touted as including new provisions and new possibilities for public procurers in the EU context to work with social as well as environmental objectives, there were, across the different phases of the public procurement process, various new mechanisms notionally introduced into the 2014 directives in terms of the technical specifications, some limited grounds of exclusion of tenders from public procurement on the basis of final convictions in relation to narrowly defined offences around child labour and forced labour, and some more flexibility with the establishment of the criterion of the most economically advantageous tender, the MEAT, so-called. Any actual procurement lawyers here in the room? No. Okay, well that's good in a way. But also a loss and a challenge with this whole discussion. So there were various things introduced to try and make this, more flexible for public authorities and to encourage them to work with sustainability. But what you then actually find is that in the orthodoxy of EU public procurement law, in actual fact, these mechanisms were in the analysis of leading EU procurement lawyers either sort of dead on arrival because they contravened other requirements of EU public procurement law in terms of transparency, due process, or other sort of competition related requirements, or in actual practice, they have not been able to be implemented. So to take one notable authority in this area, Albert Sanchez-Graz, a professor at University of Bristol, EU procurement lawyer, advanced actually a book that Olga and I wrote together a couple of years ago, a very systematic sort of dismantling even of this limited scope that was provided in the 2014 directives for public procurers to work with this, for instance, on the basis of a lack of proportionality, a lack of transparency, that the measures that could be implemented by public procurers might be challenged by other companies, and so on. So there's quite an uphill sort of challenge in actually implementing and working within the domain of public procurement law in terms of establishing greater flexibility to refer to company due diligence, the quality of due diligence, etc. Now, so they're all basically knocked out. All the provisions in the new directives of 2014, in the view of esteemed procurement lawyers, are sort of knocked out by one. So what you realize as a human rights practitioner or scholar as you sort of approach this domain is that there is a clash of paradigms. It's very quite big font there, small up there. There is really a clash of paradigms when it comes to working with public procurement and human rights due diligence. There are two fields of law that have very different conceptual frameworks that rely on different aims and objectives. For public procurement lawyers, what's key, of course, is efficiency and lowest cost, and that, coming back to the politics of this, will remain a very important objective for politicians, and and principles in local authorities or of course, other public authorities. Whereas it's also, a legal requirement, efficiency and value for money, non-discrimination between economic operators, and, at least in the EU context, economic operators can be pretty litigious when it comes to exclusion from tenders, or feeling that they've been unfairly treated in the context of a public tender process. And social and other criteria are only secondary objectives. Of course, from a human rights standpoint, it's the other way around, and actually, economic efficiency should be subordinated to respect for the fundamental dignity of the individual, and other human rights considerations. Equally, in terms, and some of this has been touched on by Neil indirectly, I think, for public procurement lawyers, the assumption is that competition operates fairly, and therefore giving public buyers to greater discretion to advance human rights through public contracting can be actually seen as a source of market distortion. Whereas for human rights lawyers, again, it's the opposite. Actually, competition on the basis of human rights abuses is what is market distorting. But getting these sort of getting these two sides to sort of engage in dialogue legally is quite hard. It still seems to be quite hard to find a way of marrying the two fields together. And then if we look at due diligence legislation, Gemma touched a little bit on this, our public authorities, and it relates to the difficulties that I've just been talking about. Are public authorities in the scope of the French due diligence law? Well, they're not, and there's no other mention of public procurement. So they haven't even tried to articulate public procurement and public purchasing with the due diligence obligations of companies in that context. The German law does provide for exclusions from participation of companies who have been demonstrated to have done something wrong until they can demonstrate self-cleaning. So that is an innovation, and something that we can, I think, look at and investigate further as a source of sort of possible inspiration here. But again, when we go back to proposals for the EU due diligence legislation, not even the Greens actually in the context of that process in the EU, not in the Parliament, were sort of brave enough to want to take on EU procurement law and include public authorities in the scope of the EU due diligence proposed due diligence duties, and neither have they sought to, again, articulate due diligence duties with EU procurement law. So, again, I think it demonstrates the scale of the challenges that there may be seen to be in making these two things work together, even if, as we have argued sort of energetically ourselves, there's everything to play for in terms of the possible impact of linking due diligence requirements for companies with public buying processes. So we've got, this current status is we've got lots of guidance on due diligence and, turning around to the issue of remedy. We've got lots of guidance for companies on how they should, even though they don't have a legal obligation as yet, to remediate harms they cause through due diligence failures or otherwise. There's lots of guidance for companies telling them, how it would be good for them to do that on a sort of voluntary basis. They're from the OECD responsible business conduct guidance. equally, yeah, in the 2021 updated European Commission guidance on buying social, which is the sort of main, the main reference point in the EU context for public buyers on implementing their responsibilities under the revised directives. Almost nothing still on human rights, and certainly on remedy and the obligation of public buyers to remediate harms to human rights caused by their suppliers or their due diligence failures. There's nothing in there. There's still nothing in there, unfortunately. And I think where that brings us to actually is that if we, we're thinking about, what can we do in this space? The two main options would be, trying to revise public procurement law to give public procurers themselves a human rights due diligence obligation and a duty to remediate linked to that. Or you can try and revise public procurement law to get it to act on companies' due diligence, company due diligence duties and their due diligence failures. And I think that probably is the more fruitful avenue to go. I think, for the reasons I've explained, I think a duty that addresses public authorities directly and requires them to do human rights due diligence and gives them a duty to remediate. Let's discuss it. But I think, I think that's going to be hard to pull off. Probably easier to get legislation on the books requiring at least a class of companies to do human rights due diligence, and then see if we can amend public procurement law to permit exclusions based on assessments made by other bodies that companies have failed to meet their due diligence duty, and require self-cleaning activities, sort of with some inspiration from anti-corruption and debarment regimes, as Neil was mentioning there, I think linked to that. So that's probably the area I think that needs, further analysis and exploration of options. And I've been beginning to think about some of this in the context also of the EU's proposed ban on products made with forced labor. So that is under discussion currently. The Commission has proposed a ban which would encompass products both made in the EU and outside the EU. It would allow investigations on a sort of risk-based approach of products by competent authorities at the national level. If suspicions were substantiated that products were made with forced labor, products can be withdrawn from the market or disposed of. That can involve inspections inside EU, again, extraterritorially, with permission of economic operators outside EU jurisdiction and third country governments. Query, how realistic that is in some contexts, but in any case. And there are also some interesting sort of provisions around setting up EU level databases on forced labor risk, guidelines on risk indicators and data sources, and also setting up a sort of EU network of actors around forced labor products. And there's also some provision around penalties, mainly in the form of fines. So the question that I've been looking at for the European Parliament is how to plug the hole in that proposal when it comes to remediation for victims. Because there isn't anything in the Commission's proposal for the forced labor ban currently which addresses remediation. So, what can we do then with that, and how does it inform the discussion here about possibly finding ways to compel suppliers to government or government buyers to take action towards remediation for victims, for instance, of forced labor, either intra-UK or abroad. I think sort of what we've, me and my co-author Amy Weatherburn, sort of where we've arrived at the moment is that, it does need to be a comprehensive package of measures from what we know already about the limits of a purely criminal approach to redressing and trying to combat, prevent, remediate forced labor and modern slavery. The approach has historically been quite focused on criminal law mechanisms, but it's not a very durable way. It doesn't address of solving the problem. It doesn't. It's not sustainable. You have problems about repeat victimization and so on. So it has to be, rather than a single-pronged strategy, a multi-pronged strategy. How could it work in this context? Well, I think in due diligence legislation that you might envisage here in UK level, you would want to make sure, of course, there's a definition of remedies which is aligned to international human rights law, which would be broad and victim-centered, encompassing the diversity of sorts of remedies that you need to really tackle root causes and ensure effective, sustainable remediation for victims. That should be in the due diligence legislation as part of the definition of due diligence required of companies. You need then to empower the enforcement bodies under UK due diligence legislation so that they can investigate, determine, and make determinations themselves about the incidence of due diligence failures. You would also need a complaint mechanism for affected rights holders to be established, alongside any civil liability provisions in order to sort of open up a multiplicity of complaint channels. Civil liability mechanisms will not suit all victims. They're not really appropriate to various kinds of human rights abuses. Tort-based actions just don't fit well with many different kinds of human rights abuses. So you need a kind of complaint mechanism. Query whether that should be linked to the national contact point under the OECD guidelines or not, and also a compensation fund for victims. So if you had those elements under the corporate due diligence legislation, then you might be able to link effectively measures on public procurement. What could they be? Exclusions from eligibility to tender for public contracts based on determinations by competent authorities under the due diligence legislation, self-cleaning provisions, and that might provide a mechanism to link to non-binding grievance mechanisms, in the sense that if you allow companies to show their self-cleaning, they could do that perhaps by engaging with multi-stakeholder based grievance mechanisms, which they might not otherwise feel compelled to do. Because they're not binding, they're not mandatory, but they might be able to be encouraged to do that if it was a way that they could discharge their self-cleaning responsibilities. It would also be good, I think, to have a duty or a power of referral of suppliers to competent authorities under the due diligence law. So public buyers might be able to make referrals to the body that's established to investigate possible due diligence breaches, possible corporate human rights breaches, when public authorities become aware of things going wrong in their own supply chains. Caveats with this whole sort of package is, that we, for the moment, we have limited evidence that forced labor bans, for instance, have worked very well, or even the measures that have been taken unilaterally by companies, or at least when they haven't been mandated, the sort of top glove scenarios. We don't know yet how effective those voluntary remedial measures by companies are in actually preventing recurring abuse. We've got the issue of institutional capacity amongst public authorities, as well as, in terms of state-based mechanisms attached to any due diligence legislation, the resource question, political support for something you know, that's as big and fancy as this. Do we have that? Is that realistic at the moment? I think you could, you know, given the sort of rhetoric that we've had even about public procurement in the last couple of years in the UK, from the government side, I think that's questionable. And then we have this whole issue of how this might interact with tort liability. Some of these measures that I'm proposing, how would that interact with tort liability under due diligence legislation if that is foreseen in terms of parallel proceedings, etc. If you've got, you know, non sort of mandatory engagement with multi-stakeholder initiatives in parallel with civil actions, which victims are allowed to, you know, allowed to initiate, you know, how are these things really going to influence one another or interact with one another? So there's a lot of, in terms of designing an overall legislative package, lots of complexity and challenges to discuss. Yeah.
Thanks so much. Thanks so much. The more you think you know, the more you realize you don't know about this area, especially someone who's studied and thought about it as much as you. We started late, but we do have some time for any contributions or questions. People who are online can do that on the Q&A or on the chat, and I can pick those up. Does anybody have any questions? Yes.
Yes. Thank you very much, and very, very interesting discussions. So many different considerations here.
Perhaps you could just introduce yourself as well, just so we know where you're coming from.
Yes, sorry. So Matthew Nelson, CEO of a tech startup called Arivu, focused on third-party due diligence. So really, really important, the topics that are covered here. I think one of the things that is that we're seeing in the private sector is the corporate culture emergence of the importance of addressing some of these issues, and yet the difficulty in addressing these social issues. I think one of the, in terms of impact and effectiveness, there are so many things that that the supplier companies can do in examining their extended supply chains. Can you share with us some of the signals that you might have seen or recognize that a supplier can be looking for in examining their supply chain in an ongoing due diligence to identify bribery and corruption activity or evidence, or perhaps human trafficking evidence? What kind of signals are there outside of whistleblower type instances?
Take 3 questions. There was a gentleman here, and then the lady next to you.
Yeah, thank you so much. Quite a brilliant presentation, like very, very, very enlightening. So I'm Sonny Ojaga, and I'm a geopolitics and strategy advisor, specializing in international trade. So with my office in Canary Wharf. So I quite enjoyed when your colleague showed us a picture of the United Nations there. So I would like us to look at this issue, public procurement and human rights, from a global approach. The reason why I'm saying this is because we have 80% of the world that has different views of this concept of human right and public procurement. So as opposed to like the US and allies, including the UK. So now 80% of the global market, what they see, let's take the United Nations for example. They see 5 countries in the United Nations that are permanent security member of the council. And if you look at those 5 countries, they also account for nearly or even more than 95% of the leading multinationals in the world. So in those countries, they also have the veto in the United Nations. So the lady mentioned the EU and even Commonwealth. So the rest of the world, what they see is that, how do you expect this country that have the veto in the major international organizations that are actually meant to be delivering global governance, how do you expect those countries to police their own multinational that has a huge impact on their respective economy? So my question is, don't you think that that is actually a huge problem? Maybe we should go back to, we should abide into the rules and the prescription of the United Nations from their constitution, which is one country, one vote. So all the countries, including the big ones, can now go out there and convince the rest of the world. So that's my question. Thank you.
Thank you. And I think just the last question is next to you. Do you have a question?
I think it was me.
It was me. Sorry. Yeah.
But if anyone has a question, I have more chances to
you've
talk to them.
You've got the mic, so.
Okay, thank you. Olga Martin Ortega, Professor of International Law at the University of Greenwich. So I have questions for the three panelists. Thank you very much. Fascinating as always. To Gemma, the interesting, of course, I'm a member of the board of the Corporate Justice Coalition as well, so obviously I support this initiative, and we have shared as well with Gemma and the unions the fear of the public sector to be exposed to liability themselves for failing on their own obligations to due diligence. So, and I think you've mentioned it in passing, and this is an important issue that may bring some resistance on the public sector itself to this kind of normative framework. So, and to what extent both Gemma and Claire, the remedy should a provision either in the due diligence legislation with the possibility of public buyers that bring it in, as Claire, you're suggesting, or a Business Human Rights Act, Business Human Rights and Environment Act that applies to both public and private sector, consider remedy outside of litigation. So a remedy that is not directly linked to a civil or criminal procedure, and that comes from other kind of grievance mechanisms. And what is the role? How do we involve the public sector in this remedy? So we are involved in the public sector in monitoring, for example, through the link to including contract clauses through electronic watch, etc. But what is the role of the public sector in remedy? And to Neil, of course, the debarment route is very important. It's established in law, and it works long term working, but that has the problem of the very limited markets, when we have very limited amount of suppliers, when we have emergency procurement, and also this kind of reshaping of the suppliers, the ownerships of the suppliers being hidden and then being able to pop up again in different forms, or in different corporate forms, and to what extent are we not going around debarment quite a lot, especially in markets that are or highly risky markets, etc. So that was all my questions. Thank you.
Thank you. Should we start with Neil, simply because the last question was directed to him, and also the question of examples of
Yes.
bribery. You can give names of corporations if you like.
And it's a great question about debarment. I'm not putting debarment forward as a complete solution, but I do think it's had an impact in changing behaviours. If you know you're going to be on a debarment list, it changes behaviours quite dramatically, because if you're cutting out a revenue stream, if you can no longer compete in a public procurement exercise nationally, then it's pretty powerful in driving compliance. So I don't think it's a perfect solution, and there will be challenges when you have a very tight or limited market. There are rules and different rules. I won't go into the technical aspects, but there are rules where sort of anti-circumvention protections in the debarment rules of some of the development banks. So you can't simply, disappear and come back again as a, a subsidiary or something. But, those could be looked at as well. But I wouldn't hold debarment out as perfect, but it does drive behaviours because it goes to corporates' ability to even enter a market. As to the other question, fabulous question as well. I do have a long list of warning signs, but they develop over different cases. We use them, and when you're looking at supply chain due diligence and spotting red flags, there's a series of different things you need to do, and I don't think it's the list itself is more points you're just looking out for. What you're doing with supply chain due diligence from an anti-corruption perspective, but I think it applies in other compliance areas, is doing a series of different things and triangulating them. So you're not just doing some screening of databases, you're not just asking for responses to questionnaires, you're testing in different ways, and you're doing it in a risk-based and proportionate way across the supply chain. The other thing that I think is a trend is that you might see, you do adverse media checks, you're doing a range of different things to try and get to a position to factor in if someone passes your diligence or not. But what you're not doing is adopting a sort of, you have to have a triaged approach, but you're not having a straitjacket over exactly what it is that is a red flag or not. Frequently we're seeing that something might be a red flag around an aspect of business culture, which is masking something much more sinister in another way, in a supply chain investigation that I might do. So you've got to keep a very open mind. It's an investigative process in the most high-risk cases.
Thank you. Gemma and Claire, there were two questions I think directed at you in terms of international will, and I got the impression that from your talk, Claire, that you thought it was all just whitewash, what was the government rhetoric and so on, and wasn't something that they seriously intended. And then there's also a question about remedy, how best to incorporate remedy, and obviously that's obviously why we're all here. We want to see change on the ground.
Yeah, maybe I can take the remedy point. I mean, I think it's good to try and break it down a bit, into what might be the sort of constituent elements there. Oh, sorry. So, if we're thinking about whether, first of all, whether public authorities should be included in the scope of a business human rights law that would give, companies then and public authorities a statutory human rights due diligence duty. So then, it would be that public authorities within the scope of the legislation have a duty to do human rights due diligence. And then, what would be the basis of a duty to remediate? Public authorities must remediate human rights breaches, human rights violations caused by their due diligence failures, just if that's how it would unfold. I mean, I think then you have to think about, okay, what does that mean? Let's take a couple of scenarios, maybe inside the UK where the human rights violations or abuses occur, inside UK and outside UK. Inside UK, what kind of human rights abuses might we be thinking of? Could be discrimination, could be modern slavery. I think it looks very different. The kind of legally, it looks very different actually, depending what specific form of human rights abuse you're talking about. In many cases, there will already be a liability on the part of the immediate perpetrator, which might be the business. So you can, I think, quickly get quite complicated to see how, a duty then of the public authority would sort of supervene on, the pre-existing liability, or duty of, for instance, a company not to discriminate. What would it be adding in that scenario to give the public authority, who's the purchaser, an additional duty to remediate beyond what either the existing criminal law provides, or beyond what existing discrimination law, or whatever it is, or if there's a statutory breach in relation to the environment. So I guess I'm not totally convinced that you can say something general in statute about what a duty to remediate would be for a public authority that would really work or make sense, or it seems quite hard to imagine how that exactly would be articulated in such a way that it would be kind of operational. Then if you think about the extra UK scenario, So, you know, if it's a global supply chain, if it's top glove or, you know, whatever. So UK public authorities who are purchasing would again have the duty to do due diligence. If harm eventuated as a result of their purchasing activity, of course, you've got causation issues, but leaving that to one side, you know, if it's articulated in terms of, okay, the NHS purchaser, for instance, or local health authority has got a duty to remediate harm to human rights caused by its suppliers. Well, you know, if it's defined in terms of human rights, then you're essentially giving a UK public authority a duty to remediate harm to human rights, whereas, you know, there is the state in that country which has its own human rights obligations, and you get into quite quickly into possibly icky, you know, territory in terms of whose responsibility is this, how will this be received by the, you know, by the country of production. So I think making it mandatory in legislation for, you know, for public authorities to remediate, when you define what they have to remediate in terms of human rights as such, is quickly becomes quite difficult and challenging. Therefore, it might be better to get the company who is on the ground to do the remediation as, you know, as a condition of self-cleaning, because then it's more, there's more discretion over what form the remediation should take. It doesn't have to be described statutorily in terms of human rights, so you have less sort of comity. I think you've got less possible risks with comity and whatnot when it comes to human rights, but you still compel the remediation by the company without, you know, but in an indirect way rather than a direct way, because we are beginning to see, you know, in the broader discussions around UN Business Human Rights Treaty and, you know, just EU due diligence legislation, national due diligence legislation, we are getting, as I think, you know, you were alluding to, the beginning of pushback from the global south, because they are not, you know, they're not at the party when it comes to deciding on the terms of this legislation. You know, the EU due diligence legislation, the forced labor ban, none of this was actually consulted on with governments of the global south. You think about cocoa, for instance, you know, we all know there are there's endemic child labor issues in cocoa production, which are hard to combat in, you know, in an easy way. Government of Ghana has, you know, for its part, passed a lot of legislation and is making efforts to address that. You know, forced labor ban, which just means that cocoa stopped at the border, doesn't really help local duty bearers to really address those problems in any meaningful way. So, you know, I think your point is valid in terms of that, and yeah.
So I just quickly would like to touch on this one part of it. The problem is not
Hold on,
actually-
wait for the mic.
The problem, what you said is very, very important. The problem is the arbitrage. Like those international organizations, they have very, very good rules. So they are not saying that the laws are not there, the laws are there, but they're like, okay, if you have like a supply chain on the other side, extra the UK, they're like, okay, why can't we just abide in the prescriptions and in the guiding principles that are already existing? Because if you check the EU, if you look at the United Nations guiding lines, they're all super. But because of this conflict of interest of the veto of those countries and the interest that they have to push their multinationals, that is the problem. We don't have any international organization that can actually stand in between and provide serious arbitrage. Thank you.
Gemma?
Well, what you're saying is right.
Thank you. So before I answer those questions, I just want to take back to the start of when the idea came up. So the idea of having a mandatory human rights due diligence law in the UK and to have a failure to prevent law in the UK was always, for us at Unison, an opportunity to try and push the envelope, to try and have a discussion and a debate about public procurement and why there are so many failures. And I think that this evening has brought that up. it also means that, it doesn't mean just because there are so many difficulties that we will stop and that we will say, no, it can't happen, because it doesn't really matter in some ways. I mean, I might change my mind about this, but it doesn't really matter in some ways about whether we get exactly what we want. Like, we know as a coalition that there's negotiation that has to happen when laws actually finally start to get written down by Parliament. The point is what can we do to push things? Because there are leading public procurers in Sweden, in Norway, and in Barcelona City Council. They're doing great work. There is an appetite for this, and so what can we do that is going to help to stimulate this and make it happen? So I just want to go back, and the question that I came to Krishnendu originally was, is it a yes or a no? Kind of, can this happen or can't it? And how do we fit this within a national public sector framework? So let's just keep exploring these, and we'll come up with our propositions, and we'll keep discussing, we'll keep pushing it, and it's going to eventually get traction somewhere, right? So that's my point here. And so we're not going to get dismayed by the difficulty of it, because we're trade unionists and we just can't give up, right? And I think that and activists and all the rest, and I think that has to be the fundamental thing that underlies all of this. So just having said that, I'll try and answer a little bit about the points. In terms of liability, it's very unlikely that we would want the public sector to be held liable, but we would want some form of sanctioning to be able to be done. It's not that everything that you apply to the private sector has to be applied equally to the public sector. So we're looking and we're exploring what can be applied to the public sector that will make that difference. Import bans or debarring, it makes a difference. Judicial reviews make a difference, but they don't end up, but again, we come back to remedy, we come back to system change that needs to happen. And therefore we do need resources. And when we talk about resources, how can there be feedback loops that come from private sector into the public sector when transgression has happened, for example, to even help to make that resourcing happen. So yeah, we just want to be creative about this, and we're on that journey now. In terms of remedy, I would say ask the workers. What matters to the workers? Where's the apology? What does it cost to make an apology? What does it cost to say we're going to look back at our systems and we're going to learn from this, and we're going to report back to you as the workers about what it is that we are going to do differently? And we are, as I intimated, we're working on a set of worker-driven remedy principles that public sector buyers of electronics products are going to be testing and putting and trying these out, and we'll be developing, as the trade union movement, a set of tools for the workers to be able to try and test these out. So I think we've got to kind of come from our perspective, we've got to come from that. It doesn't always have to come down to huge amounts of money. In Sri Lanka, the free trade zone and my brain's too tired at night, the FTZ and GSEU union, who has been continued, who are in Ansell's Lanka factory, medical rubber gloves, who've been continually union busted, whose members don't get proper overtime pay, etc. What would they like from the public sector? They'd like the public sector to tell Ansell within this debarment, obey, or within the exclusions, obey the law. There's already been Sri Lankan law that has been, there've been hearings about this, and they've said that they should be stopping the union busting. So what is there a role for the public sector? It is in saying, stop doing what you're doing, otherwise you will never ever get another contract from us. How about that? I mean, these things matter, and so I think that it's the art of the possible, isn't it? In terms of you were talking about, sorry, I didn't catch your name, about your tech startup. I would say one of those hotlines are all fine, okay, but a big sign is is there a yellow, what we call a yellow union? Like, does a union exist? Is it a bona fide, independent trade union that's operating democratically? Are the workers being asked about whether or not they've got access to freedom of association, collective bargaining? Because if union busting is going on, there's a good reason for it. I would sniff out that there could be all kinds of other things happening if a company is actively trying to bust a union. No company that's not trying to bust a union has nothing to hide. So I would say that. And the other thing I would just say, Sonny, I mean, you know, of course you make great points, but the global trade union, again, we come back to the workers, and the workers have a legitimate say in all of this. And the global trade union movement is behind what it is that, you know, collectively we're all trying to do. And so from our perspective, we just have to keep going despite the enormous power imbalances.
Thank you very much. Here at Doughty Street, we like to think we're hopeful and aspirational rather than negative and pessimistic. But yes, we've run out of time. I'd like to thank everyone for coming, everyone who's online. And I'd like you to all thank our speakers, Claire O'Brien, Gemma Friedman, and Neil McInnes. Thank you so much for getting up here on time. Claire came down from Greece, so thank you very much. I'll just end on a short quote from the World UIGA Congress case, which you may know was about transparency in supply chains, including, but in a criminal context, in which the court found that they couldn't mandate an investigation because there wasn't clear evidence to show that the forced labour in the supply chains that came to the UK. And what the court said in conclusion, it said, the outcome of the case does not in any way undermine the striking consensus in evidence that there are clear and widespread abuses in the cotton industry in the ex-UAR involving human rights violations and the exploitation of forced labour. It is clear that these agreed concerns continue to trouble the defendant, are on our subject of active policy, work and engagement. Well, we hope that that active policy, work and engagement improves the UK's commercial and public obligations to supply chains around the world. Thank you very much for coming.
Thank you.
Thank you. And there are obviously drinks and